any means reasonably calculated to reach the defendant. Was that email reasonably calculated to reach the defendant?
Yes.
Yes. The court said notice was valid. The default judgment stands. Rios 1 wins. By default. That begs the question, can you serve notice via email anytime?
No.
No, that's not what the court said, right? Only if it's reasonably calculated, and here they said, this is the only way you can reach us. So yeah, it was reasonably calculated. Can you serve someone based on the Rios decision? Can you serve someone via text message?
Yes.
Yeah, it depends, but you could, right? I know you guys, my son is a little bit older than you, so he's about your age. If he gets a text, he's getting it. It's more than reasonably calculated. It's guaranteed to reach him. And it doesn't matter where he is. He could be in the bathroom or wherever. He's got that cell phone surgically attached to his hand. I'm sure you do too, right? Someone texts you, you're gonna get it. Is it reasonably calculated to reach you? Yes. What about serving someone via social media, like Instagram or Facebook? Could you do that?
Yes.
It depends, but yeah, you could.
They use
If it's reasonably calculated to reach the defendant, right? My wife is on Facebook 24 hours a day. If you send her a message on Facebook, she's getting it. It's guaranteed to reach her. I can prove it. She's there all the time. You guys are probably on what? Instagram? Is that the social media of the day? So if someone tries to get you on Instagram, are you going to get it? If someone tries to reach you, are you going to get it? Is that guaranteed to reach you? Is it reasonably calculated to reach you? Yes, I would say it is. It depends. I think I've told you before that the correct answer to almost every legal question is, it depends. Right? It depends. So long as it's reasonably calculated to reach the defendant, it could be valid service of process. Which is why today you can use the last known address. You can send it via mail and certified mail, regular and certified mail, to the last known address. And the court will usually accept that as proper notice. Now, if you're suing for $10 million, are you going to take the chance on certified mail? No, you're going to hire someone that makes sure, right? But just know that the Rios case says you can do it via mail, regular mail. So once the defendant is served the complaint and given notice, they have about 45 days to file an answer. You must file an answer. In order for the case to proceed, you must file an answer. If you show up at the court date without having filed an answer and expect to go, the court's going to say, where's your answer? Oh, I didn't file one. You lose. You must file an answer. It's possible that you might say, oh, you're suing me? I'm going to sue you. You can attach a counterclaim. And of course, if you file a counterclaim, the plaintiff must answer that. And that's called a reply. These taken together make up the pleadings. And this is the initial paperwork. Any questions on the pleadings? No? So once the pleadings are filed, Are we ready to go to trial? No, we're a long way from that. There are some pre-trial procedures to get through. And the first is the defendant may file a motion to dismiss. Remember what a motion is?
In order.
It's a request. You're asking the court for a dismissal. Why might the defendant ask to have the case outright dismissed?
Frivolous suit, it's frivolous.
No, that would be a defense.
Oh,
You know the answer.
jurisdiction.
Yes! Lack of jurisdiction, right? Those three basic requirements must be met where the case must be dismissed. So if there's no jurisdiction, you make a special appearance and a motion to dismiss. Same thing with wrong venue and lack of standing. Those are all reasons to dismiss the case. Another reason is the statute of limitations. Statute of limitations. Anyone ever hear of that? What it says is, it's a law, and it says you have a certain amount of time to file your complaint from the day the incident occurred. You have X amount of time. And typically for a tort, which me punching you in the nose and you suing me would be a tort of assault and battery, is 2 years. So you have 2 years to file that complaint from the day I punched you in the nose. If you are 1 day late, statute of limitations says you must dismiss the case. There's also a statute of limitations for crimes. The prosecution has X amount of time to file charges against you from the day the incident occurred. Typically, it's 5 years. Some crimes have no statute of limitations, like murder. There's no statute of limitations. But most crimes is 5 years. Most torts is 2 years. Also, just keep in mind that there is something called to toll the statute of limitations. It simply means to pause. The statute of limitations pauses. The time pauses. Why would it pause? If the defendant is on the run, is in hiding, I can't file the complaint yet because I don't have all the information, or I can't file charges because you took off to France. You can't run away and hide out the statute of limitations. It pauses while you're gone. It pauses while you're hiding. So we say it tolls. Any questions on that? No? Either party can make a motion for judgment on the pleadings. And I really don't need to explain this because it speaks for itself. It is what it says it is. It is a request for judgment on the pleadings. So the judge can only look at the pleadings. And what you're saying is, if you're the plaintiff, the answer fails to state a defense. I should win. If you're the defendant, you're saying the complaint fails to state a cause of action. I should win. Right? So either side can make that motion. And the judge can end the case right there, then and there. Let's say, let's be.
let's say the motions are denied. There is something called spoliation. At this point, we know we're going to trial. Our motions have been denied. We know what's going to happen. We're going to trial. So the lawyers for each side send out spoliation letters. They go to anyone who may have evidence. And it says, do not spoil this evidence. It is in your charge. You're in charge of it. Do not allow it to be destroyed. If you do, you can be fined by the court. You can be sanctioned by the court, meaning penalty. If it's a criminal case, you could go to jail. And the jury is allowed an adverse inference. Adverse inference means the jury is allowed to assume that the reason you allowed this evidence to be destroyed is because it went against you. That's an adverse inference. So if I think you have a piece of evidence, in this case, I'm going to send you a spoliation letter, and it's going to say, you have evidence, blah, 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 do not destroy it, do not allow it to be destroyed. If you do, you could be in trouble, plus the jury gets to assume the worst. Can anyone think of a famous case where that occurred? I can think of two, off the top of my head.
Did it happen in Casey Anthony at all, or no?
Yeah.
Oh,
I forgot his name. But I couldn't get it.
How about Hillary Clinton?
oh, the emails.
She
Right.
destroyed 30,000 emails after getting a spoliation letter. 30,000 emails. She whitewashed her computer and she destroyed all her cell phones. If you or I did that, we'd be looking at 10 years in prison. But because her name is Clinton, that did not occur. But that's a classic example of destroying evidence after receiving a spoliation letter. The other one I was thinking of, you might not know, is Tom Brady. Anyone familiar with the Deflategate football case?
Oh, he was texting the ball boys and stuff, right?
And they asked for his cell phone, and he destroyed it. He was found guilty. Not based on any evidence, but based on the fact that he destroyed his cell phone and they were allowed to. Adverse inference. Why'd you destroy your cell phone? Why'd you allow it to be destroyed? We can assume the worst. It's because you're guilty. He was found guilty. So yeah, you can be found guilty based on the fact that you allowed evidence to be destroyed. I've seen cases where people come into court and say, oh, but Your Honor, it wasn't my fault. And the judge is like, it doesn't matter. It's in your charge. It's up to you to protect it, to safeguard it. And if it gets destroyed, it's your fault. So that's called spoliation. And these letters go out as soon as you know you're going to court and you want to preserve evidence. Yeah.
Can you repeat the definition of spoliation again,
Spoliation is simply letters that tell a party to preserve evidence in their charge. The most important thing, though, is that if they allow the evidence to be destroyed, the jury is allowed to have an adverse inference. Any questions on spoliation? No? Okay. Let's see. Go to D. right? D?
Yep.
A, B, C, D. Discovery. Discovery is the exchange of evidence. The general rule is there can be no surprises at trial. If you are going to use a piece of evidence, you have to let me see it. You have to turn it over during discovery. If I'm going to use something, I have to let you see it. No surprises. No surprise witnesses like you see on TV. Surprise witness at the last second. No. That could not happen in real life. You have to let me see your witnesses, who they are. No surprises. Let me see. So we're exchanging evidence. Even in a criminal case, we have discovery. Suppose, what's the job of a defense attorney? What's the ultimate job, ultimate goal of a defense attorney?
Prove innocence. Or to win the case.
To win the case for your client at all costs within the law, right? Which means if I have a piece of evidence that tends to show my client did it, I'm going to bury it, right? You're never going to see that, right? I got to help my client. What's the ultimate goal of a prosecutor in a criminal case?
To also win.
No. A lot of them think that. They want their record to look good and get that victory, right? That is not their ultimate goal.
To find the truth.
Yes!
Okay.
The truth, justice. That's the ultimate goal of the prosecutor. Which means, if they have a piece of evidence that tends to show the defendant is innocent, they have to turn it over. They can't bury it. They could lose their license to practice law. They could be sanctioned by the court. That's a big no-no. So if you have exculpatory evidence on the prosecutor's side, you have to turn it over. If you have incriminating evidence on the defense's side, bury it. Big difference between the two jobs, right? Keep that in mind. So there are many different forms of discovery. Start with a subpoena. A subpoena is an order from the court to either turn over certain documents or an order to appear. Appear what? Appear for a deposition. Anyone know what a deposition is? Anyone here ever been deposed? Been in a car accident? Deposition is sworn oral testimony out of court. Sworn under oath. So it's as if you're on the stand, right? Why do we depose people? Well, you want to know what the witnesses are going to say before you go to court. In fact, you learn in law school, in the first day of law school, is never ask a question in court you don't know the answer to already. Big no-no. You got to know what they're going to say. And we know what they're going to say because we already asked it in a deposition. And I know what your answer is going to be. Suppose your answer is different than the one in the deposition. You change your testimony. That's called impeach. I can impeach you. It means discredit. You're lying. Were you lying then or are you lying now? You
liar, I have discredited you completely, right? I've shown to the jury that you are a liar. Juries are always told, if you think a witness lied, you can disregard their entire testimony. You have impeached them. And sometimes that could be the entire case. For example, in the O.J. Simpson murder trial, the arresting officer was on the stand and caught no lie. He lied. Which means the jury can disregard the arresting officer's entire testimony. Case closed. Right? Reasonable doubt. Send everybody home. So you can use it to impeach if they contradict themselves. You can also use it to refresh their memory. Sometimes years go by before we actually get to trial. So I'm going to take your deposition now, so that 2 years from now when we go to trial, you get on the stand and say, I don't remember, that was 2 years ago. I'll read back your deposition. Why can I read it back? Because when you gave it under oath, right? So it's valid evidence. The witness may also become unavailable. It's okay. We got their testimony in the deposition. We can read it back to the jury. They may pass away, they may die, or leave the country. It's all right. We have their deposition. This was another critical moment in the O.J. Simpson murder trial. One moment for me that proved reasonable doubt, no matter what you thought about the rest of the case. The day after the murder, O.J. Simpson went to the police station and they took his blood. And the coroner marked it down as 4 cc's of blood and gave it to the detective in charge and told the detective to book it into evidence. Instead, the detective went to both crime scenes with the blood. And then the next day, booked it into evidence as 2 cc's. Right? So the trial comes, and the coroner who took the blood and swore that it was 4 cc's passed away. So he wasn't around. The officer, the detective, said, no, it was 2 cc's. That's what he's telling the jury. Don't try to bullshit me. It was 2 cc's when I got it. Well, guess what? We have the coroner's deposition on videotape where he swears under oath it was 4 cc's. And they played that videotape back for the jury. The jury got to hear the testimony even though he had passed away. So now you have conflicting testimony, right? What's the inference? What happened to the extra 2 cc's of blood?
Poured on the crime scene.
It was planted, right? That's what the whole defense was. You planted this evidence. Now they had almost proof. What happened? What'd you do with it? Why didn't you book it into evidence? Why did you take it to both crime scenes? That's a big no-no, right? Shame on you. So when that happened, I remember watching it going, that's it. Not guilty. Sure enough. Even if you thought he did it. Because at that point, it's reasonable doubt, right? And it was huge because of the deposition. So that's how important the deposition can be. It can make or break the case. So if you're ever in a car accident, you may get a subpoena saying, please appear at the attorney's office for a deposition. And that's all they're going to do is ask you questions about the case. Usually it's, what's your insurance carrier, blah, blah, blah. But it's under oath, so you got to tell the truth. Any questions about depositions? How important they are? No? Okay. There's also something called an interrogatory.
These are written questions under oath, sworn unanswered in writing. So you may get, if you're in a car accident, you may get a letter with questions. These are interrogatories. And at the end it says you swear that this is the truth, subject to punishment if you're not telling the truth. So it's under oath. And it's as if you're on the stand. And they can be read back to the jury. Well, this is what you said in your interrogatory, right? Same thing as a deposition, only in writing. I also want to know your witnesses. Got to hand over your witness list. That includes any experts. Why? What's the difference? Well, the difference is only expert witnesses can give an opinion. If you're not an expert, you can't give an opinion on the stand. So, let's say student A is suing me for $10,000, right? And then they put you on the stand. And the question to you is, was student A in pain after Professor Cooney punched him in the nose? Objection. Don't answer that. You are not allowed to give your opinion. You are not an expert on pain. You can't answer that. Only an expert can answer that question. Only an expert can give an opinion. Okay, so I want to know who your experts are so that I can refute them with my experts. What the hell? Nah. Tom Cox. That's the chairman of the department. Some people have been getting kicked out of the class for, I don't know, absences or something. Is anyone here affected by that?
But it's happening in
What's that?
it's happening in a lot of other classes.
Yeah, they're getting booted out. Oh well. So where am I? Expert witnesses can only experts can give opinions. So this is what's going to happen then during discovery. Okay? We're exchanging evidence. I want to know everything about your case. You're going to tell me everything about. I'm going to tell you about my case. You're going to tell me about your case. We know everything about each other's cases, inside and out, backwards and forwards. Are we ready to go to trial now?
Yes.
No. Not yet. Not quite yet. So, let's see. E. There's something called ADR. Alternative Dispute Resolution. And it is exactly what it says it is. An alternative way to resolve our dispute, rather than go to trial. They don't want us to go to trial. It costs money, it takes time, right? They don't want a trial. So, in New Jersey, mediation is mandatory. You have to do it. You'll get a letter that says, please appear for mediation at such and such a date and such a time, blah, blah, blah. You have to go. You sit in front of a panel, you tell them your side, I tell them my side, and they come back with who they think is going to win. It's not binding, but you have to do it. And they get paid by how many times you settle. So they're trying to get a settlement in mediation. But it's not binding. You can say thanks, but no thanks. I appreciate your advice, but
They'll probably come back and say, oh, Professor Cooney, you're gonna lose this case. You should settle it. Offer $5,000. See what happens. I would say thanks, but no thanks. So mediation is mandatory. That's one form of ADR. Arbitration. Another form of ADR, only this is binding. Their decision is final. Therefore, you must consent. It cannot be forced upon you. You have to agree to it. You tell the arbitrator your side, I tell the arbitrator my side. They come back with a decision. It's final. You can't appeal it. What they say goes. Sometimes that's good, right? It ends the case. No appeals. You don't have to pay for lawyers. Judge Judy is not a judge. She's a former judge. She's an arbitrator. That's arbitration. What you're watching on TV is arbitration. And they agreed to do it. And her decision is final. I once had a case where I represented a landlord, and the tenant's attorney called me up and said, the tenant wants to go on Judge Judy, would your client be willing to do it? And I told my client, don't do it. Have you ever seen Judge Judy? Anybody?
Yeah.
No?
I know
She's a crazy ass, wild, you don't know what she's gonna rule, right? She doesn't like the way you look at her, she could rule against you. You really wanna do that? That's not fair, right? So I always advise, don't do it. You just never know. Now you get paid for it, so you can come out ahead even if you lose, but I don't recommend it. And her decision is final, you can't appeal it. So that's arbitration. The third form of ADR is simply negotiation. The two sides may negotiate and reach a settlement at any time. The lawyers may do it, the parties may do it. I may call you up and say, look, I don't want to go to court with this. I'll offer you $5,000. You say, okay, I'll take it. We have ended the case. We have reached a settlement. The case is over. Once you reach a settlement, that's it. You can't appeal that. Your settlement is final. So, ADR, alternative dispute resolution. Let's say we don't reach a settlement. We don't want arbitration. And there are no negotiations. We ready to go to trial? No.
Okay.
Either side may make a motion for summary judgment. Typically it's done here at this point because I know your case. I have all your evidence. You have all my evidence. Either side can request the court for immediate judgment. That's what that is. Immediate judgment in your favor. We talked about this before, right? You have to know what the difference is between an issue of law and an issue of fact. My pants are black. Issue of law or issue of fact?
What's the issue of law?
It is, in fact, an issue of law. Here's why. An issue of law means there is no dispute. Nobody can reasonably argue the point. If you're going to argue it, you're not reasonable. That's an issue of law. Do we need a jury to tell us what color my pants are? No!
Judges decide issues of law. An issue of fact, on the other hand, is one that is disputable. And this is what we have juries for. My shirt is red. Can reasonable people argue about that?
No.
I think it's scarlet.
That's a shade of red.
It's a shade of red. It's crimson. You can have different shades of red, right? Which makes it disputable. I would explain to the jury why I think it's scarlet, and you would explain to the jury why you think it's crimson, and then the jury will give their verdict. That's what we do with issues of fact. We argue them, and we let the jury decide. But issues of law, there's no dispute. And the judge will make that decision. So in a motion for summary judgment, you are saying to the judge, this is an issue of law. There's no dispute. I should win. And if the judge agrees, we can end the case right then and there. Immediate judgment. That's what summary judgment means. Immediate judgment. But it has to be an issue of law. No dispute. Any questions? What did I say? Can you guys hear me? Out in TV land?
Yeah, we can.
Okay, thank you. All right, follow along on these two cases then, knowing what you now know. In the United States versus Cross. Cross is a language professor at a university. Passaic County Community College, let's say. And he takes a trip to Europe, where he goes to Germany, Poland, Spain, and when he comes back, he tries to write it off as a business expense at the end of the year. The IRS says, no, it was a vacation. Were you kidding? You owe us taxes. Cross says, no, it was a business expense. I refuse to pay. The IRS sues Cross for unpaid taxes. Cross makes a motion for summary judgment right away. And in it, he attaches one affidavit from himself that says, I swear under oath it was a business trip. The IRS submits nothing. You're the judge. Is this an issue of law or an issue of fact?
Issue of law.
You think it's an issue of law, no dispute?
The IRS didn't submit anything at all.
And what did Cross submit?
An affidavit of his own testimony.
Of his own testimony.
So it's not the full, even if the IRS submitted nothing?
Say that again?
Well, because since the IRS didn't submit anything at all, it wouldn't be a...
You think because the IRS didn't submit anything, you think there's no dispute then, right? That's the logical response. The court said, no.
Right.
An affidavit from yourself, personal statements, are always issues of fact. They're always disputable. You could be lying, right? That affidavit, you could be lying. The jury should have to look you in the eye. So, in effect, Cross also submitted nothing. We have an issue of fact. This is still in dispute. Summary judgment must be denied. The moral of the story here is personal statements are always issues of fact. They are always disputable because you could be lying. Now, had Cross submitted an affidavit from another professor
saying it was a business trip, and the U.S. submitted nothing. Well, now you got no dispute, and you would grant summary judgment. That's not what happened. Any questions on that one? Whaley versus Fowler. Whaley is suing his doctor, Dr. Fowler, for malpractice. Fowler makes a motion for summary judgment and submits 26 affidavits from 26 surgical experts. And they all say what Dr. Fowler did was not negligence. In response, Whaley submits one affidavit from his primary care physician, no expert, just his primary doctor, and he says what Fowler did was negligent. Can you grant summary judgment here?
No.
Why not?
Well, because obviously there's 26 to 1 discrepancy. There has to be some dispute between physicians.
Is there a dispute?
Oh, no, Fowler would be the one winning.
So you think Fowler would win? You would grant summary judgment? The question before you is there a dispute?
Yes.
Yes,
Okay.
there is. Even though it's 26 to 1, and it doesn't look good for Whaley come trial time, there is still a dispute. You cannot grant summary judgment here. You have to let it go to the jury. So the moral of the story here is the weight of the evidence in a summary judgment motion is irrelevant. Even though it was 26 to 1, you can't grant summary judgment. There's still a dispute. Make sense? Any questions on that? So, we got a few more minutes. Let's say your motion for summary judgment is denied. Are we ready to go to trial now?
Yes.
Yes. Yes, we are ready to go to trial. However, before we go to trial, what do we need? What's missing? What's missing? What do we need to go to trial? We have the plaintiff, we have the defendant, we have the judge. What's missing? The jury. Jury selection. It's called voir dire. Voir dire. What happens is, has anyone here ever been to jury duty? No? Alright. And you should do it. Just to go through the experience. What happens is you get your jury duty notice to appear on a certain day. You go to this big room, about 200 other people in there who also have jury duty, and you wait until your number's called. They call your number, usually there's about 25 of you, they send you to a courtroom. Once you get in that courtroom, they call you up to the witness stand, one at a time. They swear you in. You're on the witness stand, sworn in. They ask you questions.
That's what voir dire means, questions and answers. The judge and the lawyers can ask you questions to try and get a jury that they like. They can remove you from the jury pool if you exhibit any bias. You can be removed for cause. So, juror number 8, are you or is anyone in your family a professor at a university? Yeah, my brother is a professor at William Patterson. Off. Bias. Right? Say it's a criminal case. Juror number 8, are you or is anyone in your family a police officer? Yeah, my father's a cop in Wayne. Off. Bias. Right? Any bias is good reason to throw someone off the jury pool. And they're trying to get a jury that is most favorable to them. So they're looking at you and they're trying to figure out, are you a good juror? If they think you're not, they'll try to find bias and have you thrown off. Now, in addition to these removals for bias, there is also something called a peremptory challenge. And you only get 7 of these, but you can remove someone for no reason or any reason. It doesn't matter. Your Honor, I don't like the look on juror number 12's face. Remove him. Psst, off. You go home? No, you go back to that jury room. So you get 7 of these peremptory challenges and an unlimited number of bias removals. And you're trying to get a jury that you like, that fits you. Any questions so far? One last point and I'll let you go. Oh, God. Sorry, I usually turn it off. Case of JEB versus Alabama. This is a child custody case. Husband versus wife. Mr. JEB ends up with an all-female jury because Mrs. JEB keeps removing all the men from the jury pool. So he ends up with an all-female jury. How do you think that worked out for him? No. Not good. He loses. He claims due process was violated. That he was not given a fair trial because you removed all the men. We did so based on our peremptory challenges. We don't need to give you a reason. Yeah, but it's not fair. It's not fair to me. It's not fair to the jurors to remove them simply based on their gender. It goes all the way to the United States Supreme Court. Are you allowed to remove someone from a jury pool simply based on their gender? The court said, no, you are not. Let's put it over here. You cannot use a peremptory challenge based on gender or race. I don't think the court went far enough. They should have added maybe religion or sexual orientation or whatever. They didn't. You can only not use it based on gender or race. Any other reason is valid. Any questions? Comments? Criticism? Okay, then remember, unfortunately, again, there is no class on Friday. Look for an assignment to do on Blackboard instead. I'm having another treatment done, so
Good luck.
thank you. Thanks. On that happy note, have a great day, everyone, and I will see you next week.
Don't forget to do the assignments.
Yeah.
What's that?
Thank you, Professor.
Anyone coming late?